Yes. Yes.
My lord, I beg to mention item number 4, my lord.
Yeah.
My lord, in fact, on the last occasion, there is a prayer for the submitting the clerical records, my lord. But then inevitably, that has not been reflected in the order, my lord. Order sheet.
What is not reflected? What do you want? What?
My lord,
You
here.
want an adjournment?
Yes, my lord. Therefore, my lord, may I humbly pray, my lord, the LCR may be called for, my lord. And after the LCR is,
What is the matter about?
my lord, there is a direction from the special judge directing for further investigation, my lord. Despite the fact that the petitioner, he was not charged.
See, any order has to be passed on merit.
My lord.
We'll have to look into the record.
That's fine, my lord. The records have not been called for, my lord. May I humbly pray, my lord.
Record of this criminal petition, Mr.
My lord.
I don't know what is the case about. If you want an adjournment, we'll adjourn it.
Yes, my lord. But then, if it is adjourned, my lord, may I humbly pray, my lord, that LCR may be called for, my lord. And after that, it will be fixed, my lord.
So at least you wait for some time. Let the 1, 2, 3 be called.
My lord.
And thereafter, we'll look into the record. We'll find out whether the LCR is necessary or not. Is not it?
My lord.
If necessary, we'll call for. Yeah.
I further like to mention, my lord, item number 20, my lord.
20.
Yes, my lord.
Yes.
Taking the concern of the government, my lord. When we pray, the matter may be adjourned, my lord.
Okay.
3 weeks, my lord.
On the prayer of Mr. Opal and the council for the respondent listed after 3 weeks.
My lord.
Yes.
Oblige.
Please, Your Lordship, I beg to mention item number 1, Your Lord,
Yes.
on behalf of Mr. Conducting Council, my lord.
Yes.
My lord, the conducting council is not fully prepared for today, Your Lordship, to hear the matter today.
When do you want?
After a week,
On the prayer of Ms. D. Tamil and the council for the appellant listed after 2 weeks.
If I like to mention item number 21 and 22.
21 and 22.
You know, in item number 22, I'm appearing for the appellant also.
Yes.
And in item number 21, P. Modi is appearing for the appellant.
Yes.
This criminal appeal arising out of the same matter.
Okay.
Therefore, looking at it, both this matter may be taken up after 4 weeks.
After?
4 weeks.
On the prayer of Mr. K. Lawyer. Learned counsel for the appellant
Yes, Lord.
in item 21.
22.
Item number
22.
22. 22. Listed after. You have taken a consent to the other side.
Yes, Lord.
With the consent of the learned counsel appearing for the other side. Listed after 4 weeks.
4.
Okay.
My lord, I beg to mention item number 17, madam.
17.
Yes,
Yes.
Client is engaged, the learned counsel pleading there, madam. So my humble prayer is that my lord, that this matter may be fixed on 19th of September, madam.
You are for whom?
I am for the respondent, madam.
Okay. And Mr. Tapin has agreed.
Yes,
Okay. On the prayer line council for the parties listed on 19th
Yes.
September. Okay, 19th September. Oh.
much of.
May I, my lord? My lord, due to personal difficulties, my lord, my senior Mrs. Tara, my lord. So kindly adjourn for 2 weeks, man.
What is the matter? Ravi?
It is the private respondent, my lord. File a complaint case, my lord, before Chief Judicial Magistrate UP, my lord, against us, my lord.
Yes. That has been stayed.
Yes, my lord.
Why should it be stayed? Huh? 420 case.
Yes, my lord.
When do you want?
After 2 weeks, my lord.
Next week.
Okay.
On the prayer of Mr.
T comes.
T. Council and the counsel for the petitioner listed after a week.
Ma'am, my lord, we have not received the petition yet.
You are appearing for whom?
Respondent number 2.
Okay, do you have any objection?
We already, my lord, taken step, that petition already served, man.
Just a minute. You are the complainant.
Yes.
You have not been furnished with a copy of the petition.
I'm the respondent in this. The complainant in this learned Jain.
Okay. What is your prayer today?
We have not received this petition with petition.
Copy of the petition. You furnish one?
Okay.
All right. All right. Then had Mr. T comes in as a council petitioner, Miss T is in the APP for R1 and Mr.
See nothing.
C. Natung on a council for respondent number 2 who submits that he has not received a copy of the petition. So, sir, in view thereof, Mr. Kamsil and the council for the petitioner shall furnish a copy of the petition to Mr. Natung and council for represent respondent 2 during the course of the day.
My lord,
As per the council for the party
lord,
listed,
we serve-
listed after a week.
which,
Okay,
which,
all right. After a week.
May I please, Lordship?
Yes,
Lordship, this is an application under 482 CRPC, causing of the FIR number, charge sheet number 42, 22 of New Delhi Police Station, FIR number 3222, Your Honor. Your Honor, this case, what happened? Page number 19, Your Honor, annexure 1, page number 19.
Hmm.
This is the FIR. This FIR is lodged by, Your Honor, a stepmother of this one of the petitioner. Because of that family misunderstanding, Your Honor. On the basis of that, police has filed a charge sheet, page number 21, Lordship. Police has filed a charge sheet. But what happened, Lordship, during that filing of the charge sheet, police has mistakenly used that poor person name in the last para of the charge sheet, Lordship. That is in page number
26, Your Honor.
26. Lordship.
4 persons name.
Yes, the mistakenly police has used poor person name, that is Tana Takam, Tana Bullet, Takom Muni, Tana, instead of Lika Apo, Srimati Lika El, Lisi Adap, Duginape.
Page number?
Page number 26, Your Honor.
26. Page number 26 in the middle of the para.
Your Lordship will see the second paragraph, Your Lordship.
Mistakenly
Yes,
charge sheeted.
yes, mistakenly charged. Though this person is not relevant in this case.
Charge has been framed.
No, you know, at the stage of the appearance.
Oh,
So
you,
what-
you get it discharged.
no,
Your Lordship, Your Lordship,
no,
if I may explain, Your Lordship, what has happened is during filing of the charge sheet, Your Lordship, instead of giving the name of the accused who are named in the FIR, Your Lordship, another different person's name were given, Your Lordship.
Different person name has been given.
Yes.
yes.
Subsequently, what has happened is the IO had
As
submitted,
file a supplementary charge sheet.
no, Your
Corrigendum.
Lordship, IO has submitted a corrigendum before the CGM, Your Lordship, wherein correct name, there was a correction in the paragraph where the names were mistakenly noted down, Your Lordship.
Ah.
Now on the last occasion,
It has already been filed in the court.
yes, Your Lordship.
Okay.
On the last occasion, what has happened was they had filed an IA, bringing to this court's notice that a corrigendum has been filed before the CGM court, Your Lordship. At that point of time, the honorable court had made an opinion that if the corrigendum is filed before the CGM, Your Lordship, and if the CGM has considered it or not, and therefore the updated LCR was called for, Your Lordship.
So that
Well,
corrigendum,
we'll see, you go to that court. It is premature.
Lordship,
Oh.
this
482 is not for this purpose.
Lordship, this application is filed under this deed of mutual settlements, and the section 380 is non-compoundable. So it is
Nothing-
already, we have settled, you know, page number 47, Lordship.
Yes.
We have primarily settled the matter in outside the report.
What is the section?
Section is, Lordship, 480,
451,
451, 452, 380, 34 IPC. So
Ah.
380 is the non-compoundable.
What is 380?
380 is, Lordship,
Theft in building.
theft in dwelling house.
theft in the dwelling
dwelling
house.
house. Yes.
Even 452 is not compounded.
So,
That can be quashed.
lordship, that's non-compoundable, lordship.
No, that can be quashed, quashed under
Yes, that can
482.
be around 7 years imprisonment.
That can be quashed
Yes,
on mutual settlement.
yes. So we have settled the matter.
Where is that? Where is the law?
So in the Lakshmi Narayan case, lordship, since
You point out that sentence, that section 380, when the charge sheet is under section 380 and the parties have amicably settled, it should be quashed by 482.
so that lordship, non-compoundable case can be filed under 482 for quashing. Lordship. So section 482 is for quashing of the non-compoundable. On the basis, Your Honor, we have made settlement all on 15th of January 2023 in the last page number, last page number 47. Lordship.
If there is a law, we'll quash it, otherwise
Lakshmi Narayan case, lordship
Ah.
is here.
you point out a specific sentence, 380 can be quashed on a mutual settlement.
That specifically is not mentioned in para 13 is only says 482 criminal proceeding, non-compoundable offense under section 320 of the code can be.
Theft
It
in
is
a
come under non-compoundable.
theft in a dwelling house
Yes.
is not a civil dispute.
No,
It-
Your Honor.
This offense does not essentially arise from a civil dispute. Nor it arises from a matrimonial dispute.
Yeah, and this is parties, they are same family only. Because of misunderstanding, this complainant is the second wife of this Lishitaja. And this accused person are some are daughters and some are relatives of this husband of the complainant. So on that they are, Your Honor, totally family matters. So in Lakshmi Narayan case, Your Honor, it's connection to matrimonial and this.
On the prayer of Mr. T. Topu.
Yes.
List it after 3 weeks.
In this case, basically, my lord, LCR will be required because here challenge the order passed by the learned trial court, whereby the direction, specific direction has been passed to submit the charge sheet. Where the law says that such direction cannot be passed by the court, directing the investigating agency that you file the charge sheet against particular person.
Hmm?
To count here, challenging here. in this
What are you challenging?
challenging the impugn order, my lord, whereby the learned trial court below has directed the investigation officer that you file a supplementary charge sheet against this particular, against the petition.
Okay.
You know. So law says that such direction cannot be passed. Even
Yes. What do you say?
Therefore, my lord, I was of the opinion that the LCR may be required, my lord.
Just a moment. What is that order?
my lord, order might be fine. It is number
21.
21 operating portion, my lord.
Page
from-
number?
From the below, second paragraph. In the attending facts, OC is directed to endorse the case to the renewal of period further in this, and the offending portion is the file the supplementary charge sheet within so and so. And subsequent order is also cognizance has been taken without there being any prosecution sanction. There is a bar here. So these two order 21, 22, it's are under challenge. And on last occasion, my lord, argument was helped or in respect of this aspect and on prima facie being satisfied about the apparent illegality, stay order has been granted.
But trial court can direct for a further investigation. Okay. So we'll cause this and in the attending return of director endorse the case to eligible officer for carrying further. We'll cause that part of the order which directs is to file a supplementary charge sheet. But will not interfere with order for carrying out a further investigation. You know that?
That can be done, yes, my lord. But,
Investigation, that is always,
Yes,
that is always
there, madam.
available with the investigation agency.
but then, my lord, here,
Always available.
the impediment is that, my lord, that without any prosecution sanction, as since it pertains to the PC Act, my lord, whether it will be possible or not, my lord, to carry on the further investigation. Otherwise, we have to seek for an approval from the competent authority under section 17A. And then even if
No,
after,
this first investigation
my lord,
leading to filing of this first this charge sheet
my lord,
was done after obtaining approval sanction.
not at that point of time because it pertains to 2015. The case pertains to 2015, my lord, and that amendment was made in 2018, 17 or 18, my lord. So, but as for the new amendment, my lord, 17 it comes into play, my lord. So we have to seek approval from the competent authority, my lord.
But he has to investigate the incident which took place in 2015.
My lord.
So how the
But again,
how the sanction-
thereafter, my lord, even if after investigation also, my lord, we need, in order to prosecute, my lord, we need to get approval from the competent authorities. The sanction has to be accorded, my
see
lord.
that you do whatever is appropriate.
My lord.
This is a petition by him challenging the order of further investigation and file a supplementary charge sheet.
My lord.
To that extent only. So he himself will say that the further investigation is always.
That is
available
there,
to
my
the-
lord. That is there, my lord.
And to file a supplementary charge sheet, the court could not have directed.
My lord.
You know that?
My lord.
This is Mr. Arson, the counsel for the petitioner, and Mr. Opada, the special PP for the state. This is an application under section 482 of the Code of Criminal Procedure 1973. Challenging the order dated 23 to 2023 passed by the special judge PCA UPA in PCA number 02/21 in SIC Vigilance PS case number 13/15 and 10/16. There are two cases.
Two cases, they were, they have been clubbed as one case.
Okay. Under section. This is verses. You look at the verses at page 20. Page number 20 is the impugn order.
Yes, madam.
But
This is,
this is versus accused Hura Kaku
and three others.
and versus whom?
Accused is Hurakaku.
Accused Hura Kaku.
State versus Hurakaku and three
Okay.
others.
That state is missing, na? Is that it?
SIG vigilance, there hasn't been written. Instead, actually, state should have been written.
We'll add state. State versus, that is what I was. State versus accused Hura Kaku and three others. Under section 120B. Stroke 409, 420, 465, 468, 471 IPC read with section 13(1)C D2 and 13(2) PC Act 1988. Charge has not been framed.
No,
Okay. By the aforesaid impugn order dated 23/2/2023, the learned special judge PCA UPA has directed the OCPS SIC Vigilance Itanagar to endorse the case to eligible officer for carrying out further investigation and file the supplementary charge sheet within 60 days from the date of receipt of the order. Before that, you write the impugn order dated 23/20/23 reads as under. You quote this order at page 20. From perusal of the aforesaid impugn order dated 23/2023, it appears that the learned special judge PCA UPA has directed the OCPS SIC Vigilance Itanagar to endorse the case to eligible officer for carrying out further investigation and file the supplementary charge sheet within 60 days from the date of receipt of this order. Receipt of the order. When a counsel for the petitioner contends that though the court has the power, though the trial court has the power to order further investigation in the case, but the learned trial court does not have the power to order for filing of a supplementary charge sheet within a specified time. Post the opposite argument advanced by the learned counsel for the petitioner has not been disputed by the learned special public prosecutor insofar as direction to file a supplementary charge sheet by the learned trial court is concerned. Having heard the learned counsel for the parties on perusal of the materials on record, it being the settled position of law that the trial court has always the power to direct for a further investigation to be carried out in a case, depending on the facts and circumstances obtaining in the case. That, however, does not necessarily that power, however, does not carry along with it to direct the direct the investigating authority to file a charge sheet on the investigation carried out first. In that view of the matter, this petition under 482 succeeds, and the order dated 23 to 2023 passed in case number so and so. Then this case number so and so is interfered with to the extent the learned trial court, special judge PCA UPA has directed to file a charge sheet, to file a supplementary charge sheet. Full stop. Needless to say, it shall be open. Needless to say, the SIC shall carry out further investigation of the PCA case number so and so as directed by the London Special Judge PCA by the opposite order dated 23 to 2023 and do the needful in accordance with law.
I got this supplementary consequential supplementary charge sheet that was filed, that may be caused annexure 4.
Supplementary charge sheet was
Yes,
also
yes,
filed.
pursuant to
Okay.
annexure 4, page number 35.
Annexure
4, page number 35. 35.
35.
35.
You came here after the charge sheet was also filed.
This, I came here when the cognizance was taken and notice was issued to me, because otherwise
No,
I will not come.
Just
Well,
pursuant to this, a charge sheet has been filed.
fine. Then cognizance was taken, then notice was served to me, then
Just,
only
just a moment. Where is that charge sheet?
charge sheet page number 35, my lord.
35.
Supplementary charge sheet.
No, you can't. Then you can't come at this stage.
No, no, my lord.
See, just
Yes,
I'll tell you. What is that?
page number 35.
35. 24/4/2023.
Yes.
Is not it?
Page number 35, dated 24/4/2023.
24/4/2023.
23.
Now this person has been made accused.
Accused.
That what is his name? Rido Tarak. See, now during the course of an investigation, if materials have been found against you, why should the investigating authorities not file a supplementary charge sheet against you?
No, I am not on that point. Can do independent.
No, see, just a moment.
Yes,
Now it's now too late in the day to contend that. See, when have you filed this petition?
this was filed.
After the charge sheet was filed?
After the charge sheet filed and when the someone was received from the trial court. It was filed 26/6/2000.
28/6,
23, yes.
much after the,
Yes.
you just, then your petition will not succeed.
So,
Just a
Yes.
moment. This charge sheet is also under challenge.
yes, yes.
Okay.
Because Your Honor, if order is wrong, Your Honor, all the consequential things will be wrong.
Then, okay, then
Yes.
you write like this. Does the charge sheet say that the charge sheet has been filed because of the direction by the trial court?
In accordance with the order as directed by the.
Where is that?
Otherwise, this charge, it is not something.
Where is that? Where is that? Not because the material against you have been found, but because.
Here again, Your Honor, law will come here again.
Yes,
Then Your
yes.
Honor will need to examine why I'm saying that even for filing this supplementary charge sheet for further investigation on the basis of the same material cannot be filed. There is another aspect also, Your Honor. So here, Your Honor will find, I will show you, Your Honor. Yes, Your Honor. Kindly please, page number 38 of the charge sheet, Your Honor. Second paragraph. This is not something independently this power has been exercised, because when there is a direction that you have to do in a particular manner, then pursuant to that particularly manner, in that way, this has been filed. So that's why,
This is a supplementary charge sheet.
yes, madam, page number 38.
Just
That's
a-
why the action has been
let
initiated.
us bunker. Yes, that's all right then.
Timing.
Huh?
Determine what for timing.
Time being. All right. Right.
May Your Lordship.
Hmm.
Lordship, this application has been filed under 482 for quashing, Your Lordship. Quashing of New Zealand PS case number 48 of 21 under section 417, 420 of IPC, read with section 138 of NI Act.
Hmm.
Lordship, at the very outset, I would like to submit, Your Lordship.
Hmm.
This case is predominantly of a civil nature,
Hmm.
Lordship. FIR is in page number 15, Your Lordship.
Who appears for respondent or true?
Till date, R2 has not been represented, Your Lordship.
To notice served.
Notice served.
Bakalatnama not yet filed by. Yes, why it is listed today? What for it? is listed
Your
today?
Lordship, I have been appointed as amicus. I have received a copy on
Okay, okay.
Lordship, so this matter has been listed. I'm appearing for the first time.
All right, all right. Did they stay also?
Yes, Your Lordship. As per the order dated 7/9/2021, this matter, the proceeding was stayed.
All right. All Miss Ellen, anything is to be called? Nothing, huh?
CD was called for. Your
CD,
Lordship.
CD is there.
It is with you.
Yes,
Why the CD is necessary? Okay, anyway.
because it's under investigations.
All Miss N only on the council, amicus.
Amicus.
Amicus for the petitioner, representing the petition. G. Tadu, learned APP for the state. Respondent, none has appeared for respondent number 2, despite service of notice. It's none as appeared for the respondent number 2. List it again. After 2 weeks,
Lordship.
2 weeks.
All right.
Obliged.
Here also, Lordship, I'm appearing in item number 6, Your Lordship.
Hmm.
This is a POXO matter, so
Last occasion, they yet to file affidavit, Your Lordship. Opposite parties is not yet filed affidavit.
Yes.
Yeah, my lord. My lord, I am appearing on behalf of Omoti,
Ah,
London Council for the respondent, my lord.
yes.
I may be allowed 4 weeks time to file counter affidavit, my lord.
Revision petition affidavit is required. We are challenging what?
Your lordship, here we are challenging the execution petition. This is relating to the land dispute. Respondent has filed complaint before the village authority.
Mr.
T Tarin,
T.
Tau Tarin,
T. Tarin,
T Tarin,
learned counsel for the petition, and Mr.
and Novang, my lord.
N. Luang,
Novang, my lord.
Novang. Learned counsel for the sole respondent,
Yes, my lord.
sole respondent. On the prayer of Mr. Novang, learned counsel for the respondent, listed after 4 weeks.
Obliged, my lord.
Find out affidavit in revision petition is necessary or not.
Your lordship, interim was passed.
Interim order passed earlier, shall continue till the next date of listing. Okay. Yes.
Mine is also connected to same matter, your lordship.
Hmm?
Same matter, relating to same matter.
Same matter.
Yes, here we are challenging.
Novang is also there.
Yes, my lord.
Same order.
Yes, same.
Novang. 4 weeks. Here interim order is there.
Interim was earlier there, but no, we are
Okay.
declined to continue.
Here no extension of interim order.
Obliged.
Yes,
Maybe continue.
item number
5, your lordship.
5.
Lordship.
Okay.
Order dated 7/9/21.
5 interim order passed earlier, shall continue.
Okay.
Item 5. Yes. Respondent is what?
Last occasion, we left. And I also some more time. There is some more time to file the.
Sole respondent. Sole respondent.
Yes, I'm the sole respondent, and today I'm going. I'll file
Yeah, yeah,
collect the amount.
All right. Ask Mr. Huh?
T Lampung.
T.
Lampung.
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 Learned counsel for the petitioner and Ms. D. Yoka.
Yes,
Learned counsel for the sole respondent.
complaint case. Complaint case.
When shall we list it? When shall we list it?
Yes, Lordship.
After.
When shall we list it?
After 2.
Lordship, in this matter, I think if it's possible, Lordship, it's a fixed date may be given so that I can. the matter could be-
When?
Hmm. Next week,
Next week?
Monday.
Monday.
Okay. On the prayer of learned counsel for the parties, list it on Monday, give the date. Okay. What is the matter about Aravind?
Criminal revisions petitions
Challenging what?
challenging the appeal which they have filed before the appellate court, that is a session judge in the UPR for the offense under section 138 of the Negotiable Instrument Act. And that appeal was being dismissed. And actually it was being dismissed with the directions to surrender the appellant, that is the applicant of this revision petitions, to surrender before the CJM court, because he was being convicted by the CJM court in an NI Act, your lordship. So they have filed challenging that is a direction that was being given by the session judge to surrender before the CGM, the UPR. And they invoke the revision jurisdictions of this lordship, challenging the, I think the impugned order dated 16/5/2020, the 3A lordship.
Okay, Monday.
That can be.
Yes,
This is a jail appeal.
jail appeal.
Yes, the appellant was convicted. Section 3/621 of it is related with section 4 of the action.
To undergo 10 years of grace. Hello,
Which section?
my lord, the section 376 2
Okay.
1
Yeah.
IPC, read with section 4 of that. Correct.
POCSO.
Yes,
Victim has been,
about informant has been made party.
informant has been made party.
Yes.
Notice issued.
Notice.
As per office note, no step has been taken yet.
This is what? Jail appeal.
Yeah.
Yes, Jalab.
You are in amicus.
Yes.
LCR received.
Completed upon the private respondent.
Service is yet to be received. This is also POCSO matter.
No,
This is 498.
AN 323.
498.
Yes.
What? Amicable settlement.
No, Your Lordship, on merit.
This is a passing of FIR.
Quashing of the FIR on merit. Okay, heard Mr.
Pahi,
T
Pahi, PHI,
P A
HI.
H I Pahi. Lana counsel for the petitioner, Ms. T Jenny Lana APB for the state replacement 1. When was the steps taken?
There was a direction on 26/7/23 for fresh steps.
20,
26/7.
26/7. Okay, you have taken steps.
Yes.
Await service report on respondent number 2 as indicated in the office. Note dated 21/8/2023. In view of the above, list it again after
2 weeks.
3 weeks. Huh?
2 weeks.
2 weeks, okay, 2 weeks with service report of respondent number 2.
Number 14.
Etiquette in respect of R2, not yet to receive again here also.
You are challenging what?
The charge sheet and the provisions taken by the court.
What is wrong there? What is the wrong in taking cognizance?
It is nothing material.
No material.
Yes.
Then you get it discharged, get yourself discharged. You have filed the petition and the court granted stay.
Your lordship, at first place, this is not at all mentable for quashing of charge sheet because
Why have you not opposed it when the court was liberally granting stay of the proceeding? See,
it was not.
how many case this Anini court has? Huh? You go to Anini, enjoy the beauty, get a discharge. And if we stay in this manner, what the Anini court will do?
However, lordship, under court, it doesn't add.
482. 480, when nothing survives, when no remedy is there, it is for that purpose 482 has been given. And now you are resorting to the last resort of the court, and this court is also liberally exercising the last resort. Huh? Yes. 482. Do you dismiss? You'll have a chance to go to Andini also.
Lordship, let R2 appear. Services yet to. Recently, we have taken the.
But this is, see, this is not a good practice. There are, unless you make out a strong case without jurisdiction, something that type, patently illegal, why the proceeding in the trial court should be stayed?
Here applicant is one accused, but there are three accused. So charge sheet,
No
It
reason,
does.
no reason, nothing. You should notice, stay, call for the LCR.
it was not me on that day. By some our other colleagues.
Hmm.
Your lordship may peruse order sheet, type copy 78, page 78.
Which is the impugn order? 29/6/2010. That is charge sheet, is not it? Yes, 29/6/2010. Page number?
Type 35,
30.
type copy is page number 35 to.
Hmm.
39.
35. Complaint case,
FIR, yes.
GR case, GR case.
GR case.
What is the CS number?
Charge sheet number 11.
Okay, charge sheet number. How many of you have been charge sheeted?
Only this accused person.
Only this.
However, cognizance was taken against other two accused person.
No, this is 29. What is the date of the charge sheet? In your type copy, you don't type out again.
Type this page number 35.
What is the original?
Original is 20, page number 28 to
28.
28 to 34.
No, this is the substance of the charge. Charge sheet is dated, I think 2/10/2009. 2009 charge sheet. And
Cognizance was taken on the.
when, just a moment, when?
No,
27,
yeah.
27.
2/10/2009 is date of FIR and date
Oh.
of charge sheet is 29/6/2010.
2010.
Where, which page?
No, second serial number 2.
Which page?
Type copy is
Page
23.
number, page, no, first the original. This is first information report. Finally, at page 21. 21 is the charge sheet, I think. (11/10). Yes, charge sheet was
29/0.
filed on 29/6/2010.
Yes.
Now, when was the cognizance taken?
In page number 74.
Page number 74.
27/07.
74. 27/7/2021.
Your Lordship, this is more prayer. Besides having no implementing behavior here, even the accused person has undergone reverse surgery for 2 times. He is in now Delhi, so.
No, but why can't you ask for a discharge? If there is no material, there is a provision for discharge. is not it? 482 is for what? It is when nothing remains. When the petitioner doesn't have a remedy or inherent power to do justice.
Prime accused actually.
Huh?
Instant applicant is a prime accused.
Fine.
Prime accused, however, when after perusing all the records, even the IO has not
See, 482, the court is required to look into those meticulous details, no? There are several tiers now, huh? You get a discharge, if not, if there's no material, then you can come to us. Revision.
my humble prayer only this that 2 weeks time will be given because
This is not a good practice, no? You get discharged from there, we'll dispose it off. It doesn't look nice. Huh? What is the ground? There's no ground for filing 482. And when is the next date fixed? When was the next date fixed?
was
27/8 for appearance. See, 27/8 is yet to come.
2020
2021.
page 77.
Just a moment. See, this case is getting curious and more curious. This is the second impugn order, isn't it?
No,
27/7/21. You are challenging the charge sheet as well as this order,
yes,
taking cognizance of
yes,
any other order.
is two order.
Then what happened on this 27/8/21? Mr. Koyu, what happened thereafter?
I have no idea. Because even during the
Miss
pendency,
Miss Jiri, you also listen to this case. Very curious. I did not. Gradually facts are coming up. And Tado was not there on that day. He's not there.
Yes,
So
first day.
see, you see, this petition under 482 has been filed, challenging. How many persons are charged with it?
charge sheet only one, however, cognizance has been taken against 3 accused, including.
Just a moment. Charge sheet was filed against whom?
The present petitioner.
You,
Yes.
okay. You. What is that? No, what is the name? In the
Hold on.
charge sheet, in the charge sheet?
It's in page number 21,
21.
serial number 11-1.
Okay, yes. You're the only one, is not it? Okay. Now see, charge sheet was filed on 29/6/2010. Is it correct?
Yes.
Ah. Against this person. Now, thereafter, next order which we come to know is after 9 years, 10 years, 11 years. 27/7/2021. Of course, this court at Anini, judicial magistrate was posted, I think 2 years back only,
Yes, 2020, Your Lordship.
2020. No, in between, in where this case was lying, we don't know. Deputy Commissioner or rowing, CJM rowing was also there, we don't know. Nothing is there. Now, after 11 years, this order is passed, taken cognizance, is not it? Then fixed next date of appearance on 27 August 2021. Okay,
Yes.
this date is very interesting. Then thereafter, we don't know. This petitioner has not brought thereafter anything. What happened thereafter? So on 27/8/21, he must have appeared. Court must have passed some order.
Yes, Your Lordship.
Case proceeded. We don't know at which stage. No material is there. The petition ends at 27/8/2021 and then comes before this court on 22/6/2023 under 482. Challenging the charge sheet filed in 2010 and cognizance taken in 2021. Now, what this court does, you should notice. Then further proceeding of the GR case is stayed.
Yes. Lordship, how, it seems that he was discharged on the white order dated 27/7 itself, Your Lordship.
He was discharged. Where it is?
No, Your Lordship, there was a prayer for his discharge.
Now, without knowing what happened thereafter, 2021, after August 21.
Therefore, may I pray that the
Nothing doing.
Then otherwise also Lordship has rightly pointed out that for section invoking section 482, Your Lordship, if there is no proviso in the CRPC, Your Lordship, that's when it comes and the court has to sparingly invoke 482, Your Lordship. And also the party should come with clean hand, including all the
See,
orders.
Just
thereof.
has the LCR come? Trial may have been concluded also. See, when this case was taken up on 22nd June 2023, does this court know about the status of the case? Suppose the trial had concluded, it will be very embarrassing for this court. 28/6/2023, the case is fixed for appearance in view of the possible. The proceeding in the present case shall remain stayed. When the case You are not appearing before the court, absent, without the steps, with the steps. Absent, absent one, absent two, absent three, absent four. Absent five. Absent six without the steps. Absent eight. Absent nine. Absent 10. You are not attending.
Lordship, may I
Absent 11 without the steps. Absent 12, 13. Countless. Here also, here also. Yes. Cognizance taken on 27/7, is not it?
Yes.
All right. Mr. B. Koyo. Very interesting.
Lordship, it's not here. Kita home is in other court, may read the thing.
No, there are various dimensions to this code, yes, to this case.
And comparison is definitely.
Mr. B. Koyo, learned counsel, B. Koyo, no? R. Koyo, learned counsel for the petition. And Mr. G. Taro, learned APP for the state. By means of this application filed under section 482 CRPC 1973, the petitioner has put to challenge the charge sheet dated 29/6/2010 in GR case number 31/2021 arising out of Anini PS case number 11/2010 under section 406/407 IPC 1860.
Lordship, small indulgence,
Also put to challenge is the order dated 27/7/2021 passed by the learned JMFC Anini in GR case number 31/2021 taking cognizance of the offense under section, GR case number, arising out of any PS case number so and so, taking cognizance of the offense punishable under section 406/407 IPC against the petitioner along with one Sri Jayanta Bora and Sri Punyo Apum. Full stop. There is a page name you will find at 77. This court by an order dated 22/6/2023 while issuing notice and calling for the scanned copy of the LCR had stated the proceeding of the GR case number 31/2021 under section so and so pending before the learned JMFC Ani. All right, stay without stock of stay. Full stop. The scanned copy of the LCR is called for by this court by the order dated 22/6/2023 has been received. Full stop. On perusal of the records received, it appears that after the case was taken cognizance of by the learned JMFC, Anini by the order dated 27/7/2021 fixing 27/8/2021 as the next date of appearance, comma, the case was listed before the court of JMFC Anini on 27/8/2021, comma, 27/9/2021, (29/10/2021), 29/11/2021, (28/1/2022), 28/2/2022, 28/3/2022, 28/4/2022, 30/5/2022, 27/6/2022, 27/7/2022, 29/8/2022. 28/9/2022. 28/10/2022. 29/11/2022. 30/1/2023. 28/2/2023. 28/3/2023. 27/4/2023. 29/5/2023. And 28/6/2023. On none of the dates fixed as above, the appellant was present before the Honorable JMFC. Anini. Considering the above, that proceeding of the GR case number 31/2021 pending before the court of JMFC Anini could not be proceeded further after the cognizance of the offense under section so and so was taken up by the JMFC by the order dated 27/7/2021 due to non-appearance of the petitioner before the JMFC Anini, and also having regard to the fact that the petitioner would have all the remedies provided under the CRPC before the trial court, as well as the appellate and revisional court once the GR case number 31/2021 proceeds. I am of the considered view that no case for interference by this court under section 4 in exercise of the inherent power of this court under section 482 of the CRPC has been made out by the petitioner. First off, accordingly, this petition filed by the petitioner under section 482 of the CRPC challenging the charge sheet dated 29/6/2021 2010 in GR case number 7 and the order dated 27/7 passed for example in the GR case number so and so is hereby dismissed on being found to have no merit in the case. Resultantly, the interim order passed on 22/6/2023 stands vacated. Passed on 26/2023 is taking the further proceeding of the GR case number so and so pending before the JMFC Anini is hereby stands vacated. Which is, you're good, you have come. It's a curious case. You,
Only my lord, there was a charge sheet, my lord. It's already one of that.
only the lawyer has to be appreciated who had appeared in this case and got an interim order on 22/6/2020. We have discussed a lot.
My lord, actually, there's a contradictory one. Although they say that the PDS, I think that was not transported, but that was later transported.
No, we are not on the merit.
My lord,
See, you may have they may have no case against
my
you.
lord, my lord.
Well, nothing on that. And we have received the
LCR.
LCR also. We have Perus also. We have recorded, you see the order.
My lord.
What is the matter about? What is the matter about? Crossing
Yes.
on merit. On merit. Not on amicable settlement. Okay. Who is respondent number 2?
The complainant, wife of case number 1.
Huh?
Charge-
Already charged it. Third, Miss Pamela, counsel for the petitioner, and Mr. G. Tado, learned APP for R1. Average service report on respondent number 2 is indicated in the office note dated 21/8/2023. List it after 3 weeks.
Obliged.
Thank you.
My place, lordship.
Yes.
Lordship, because of miscommunication, I have not taken steps yet to the private respondent number 2.
Okay.
So lordship, I may be allowed 2 days time to take a step.
Mr. K. Roland, counsel for the petitioner, Miss T. Ginny, learned APP for 1. In view of the office note dated 21/8/2023, Mr. Roland, learned counsel for the petitioner is granted further 1 week time to take steps for service of notice upon respondent number 2 by registered procedure as well as the usual process listed after 4 weeks.
On last occasion, LCR has been called for, but
It will come in due course. It has come.
deeply obliged.
Item number 23-24.
Okay.
Yes, Lordship.
Yes.
Lordship, I have given my statement on 21. Before the IOL.
After we find the statement of the accused on page number 8 and 9.
Page number
8, the lot.
8. Abuzum Padum.
Yes.
Lordship,
And where is the statement of the other one?
Page number 9, Your Lordship.
Oh, gum. Which section is non-variable?
295 Lordship.
What is religious one?
Yes.
Yes,
Lordship.
Lordship, my humble submission, Lordship may allow them. Lordship, with regard to the dismantling of the graveyard area, that the allegation that is made in the FIR, there is a different section that with regard to dismantling of graveyard that comes under 297 of the IPC, which is a bailable offense, Lordship. And Lordship, with regard to the worshipping area, Lordship, I didn't enter into the premises of the Loni Pole area, Lordship.
When was this statement recorded?
21st, Lordship, 21 of this, 21.
21st.
Yes, Lordship.
So your apprehension is ill-founded. You could have been arrested on that day.
Lordship.
They have no intention to arrest you.
Lordship, in that, on that ground, Lordship, may allow my application, Lordship, because Lordship, my application is that I may be Lordship in the, even in the letter.
Mr. Tita, Islamic Council for the petitioner. And Mr. T is in London APP for the state. This is an application under section 438 of the Code of Criminal Procedure for granting anticipatory bail to the accused, namely so and so, in connection with Pasigat PS case number 66
Lordship.
of 2023 under section 295 for 47, 428, and 34 of the IPC. For granting anticipatory, granting pre-arrest bail to the petitioners, namely so and so, who apprehends arrest in connection with Pasigat PS case number, so and so under section so and so. Case diary called for by order dated 16/8/2023 was produced by the London APP on 21/8/2023, on which date it was also apprised to this court that notice under section 41A of the CRPC has been issued to the applicant to appear before the investigating officer on 21/8/2023 at 10:30 hours for recording his statement. First, in view of the above, the London additional public prosecutor was directed to produce the updated case diary, including the statement of the applicant recorded on 21/8/2023. By the order dated 21/8/2020. Did I say by the order dated earlier? Okay. Also, pursuant thereto, then don't repeat. Pursuant thereto, London APP, Ms. Ginny has produced the updated case diary along with the statement recorded of along with the recorded statement of the applicant who had appeared before the IO on 21/8/2023 pursuant to notice issued under section 41A CRPC. Post having perused the case diary as well as the statement, as well as the recorded statement of the applicant under section 61 of the CRPC by the investigating officer pursuant to his appearance before the IO on 21/8/2023 in terms of notice under section 41A of the CRPC issued to the applicant. This application for pre-arrest bail to the application for this pre-arrest bail to the applicant is hereby allowed. Also, accordingly, in the event the petitioner is arrested in connection with so and so case so and so by the arresting authority, he shall be released on furnishing a bond of rupees 10,000 with one surety of like amount to the satisfaction of the arresting authority on the following terms and conditions. 1, 2, 3. Same order.
W.
You,
May I please, your lordship?
hmm,
Lordship, I on behalf of Udeka, matter is speaks for supplementary. Due to his medical some complication, he is unable to attend. The lordship matter may be attend for today as well.
okay,
Instead of the 2 weeks.
after 2 weeks?
Yes.
All right. You are for the appellant,
Yes, on behalf of Udeka.
yeah, on the UDECA.
Yes, because.
Where is my? Okay. 18 and 19, no?
Yes.
Okay. You are appearing for
For the respondent one.
respondent 1. Mr.
B or A.
B. Learned Counsel on behalf of Mr. U. Decker, Learned Counsel for the appellant, and Miss M. Likha,
And yes,
Learned Counsel for which respondent?
one.
Respondent number 1. On the, do you have any objection? No.
Not.
Okay, on the prayer of Miss Oril also, on behalf of Mr. Decker, listed after 2 weeks.
Yes.
Okay.